Good morning, everyone, and thank you so much for attending today's webinar on exploring key elements of an equity-focused, smoke-free multi-unit housing model ordinance. As Stephanie said, I'm Marisa Katz. I'm a staff attorney at the Public Health Law Center, and presenting with me today is Rachel Callanan, lead senior staff attorney for Minnesota Technical Assistance in our Commercial Tobacco Control Program. The Commercial Tobacco Control Program is a team of attorneys, policy analysts, and support staff working to address public health through the power of law. We also have a team of attorneys and policy analysts who work on healthy eating and active living, as well as on climate justice. The Public Health Law Center, housed at Mitchell-Hamlin School of Law, is based in St. Paul, Minnesota, and is situated in the tribal and treaty homelands of the Dakota people. This land acknowledgement was developed by the Native American Law and Sovereignty Institute at Mitchell-Hamlin and is being used here with permission. For more information on the Indigenous peoples in these tribal lands, we encourage you to visit the URL listed on this slide. The Public Health Law Center offers free legal technical assistance to communities, public health advocates, and other partners. We also publish on important issues pertaining to commercial tobacco control, and we offer trainings and webinars. We do not, however, provide direct legal representation, nor do we lobby. Equity is a primary value of our organization that shapes all aspects of our work, including smoke-free housing policies. The social determinants of health inform our work at the Public Health Law Center. This means acknowledging that there are several factors that influence public health, including structural racism, political determinants of health, housing, environment, and a variety of other social determinants. In the context of our discussion today, we want to make sure we are creating policy with the social determinants of health in mind. We never want to offer policy solutions that would cause someone to lose their job or lose their housing and subsequently impact their health. Instead, policy should seek to balance the goal of protecting the public from secondhand smoke exposure with knowledge that punitive measures are unlikely to help those struggling with tobacco addiction. Research tells us the best approaches to help those confronting tobacco addiction are a combination of counseling, education, and nicotine replacement therapies. So with that in mind, when creating policy, it's important to remember that if at all possible, we should promote and enhance cessation support in conjunction with the creation of new policy. And with that, I will turn it over to Rachel, who will get us started on today's subject matter.
Great, thank you, Marisa, and welcome everyone. It's great to see so many people interested in this very hot topic of smoke-free multi-unit housing. I'm going to talk, before we get into some of the real nitty-gritty details about the policy, I wanted to just share a little background about the process of how we got here. And I want to really emphasize that this current model represents about 3 years of work with a wide range of partners that we worked with. But it really builds off of decades of work by organizations and advocates all across the country that have been working both on public policies like the one we're going to talk about today, but also the private individual policies. And I don't want to understate how important that work has been over the years. And so next slide, I want to talk about the specific Minnesota process and just give you a couple of highlights about the process. The process we were engaged in really was initiated by the City of Bloomington and Association for Non-Smokers Minnesota. And they initiated this process with funding from Blue Cross Blue Shield of Minnesota and the Minnesota Department of Health. And all of that funding came together to allow all of us to work together as partners to really take a fresh look at what an equity-centered smoke-free multi-unit housing ordinance may look like. And so we're going to get into the details. Next slide. I just wanted to note that because this process was such an intensive and really important process for us, I wanted to just highlight that this is the second in a series of webinars that we are doing on this model. And so you absolutely should go and check out the webinar that we did back on January 25th. That Marisa moderated, and we had a wonderful panel of our equity enforcement advisory committee members to talk about the importance of the process and centering equity. So go back and check that out. I do want to also emphasize that this is an iterative process. And we have, really, I view this model policy as a snapshot in time, but we really have, the ability to go back and grow and learn as more communities implement the policy. We'll learn from that as new developments come to fruition. We have the ability to go back and really continue to evolve this policy. And we should. I mean, that is the whole point of getting these model policies out there, is to then learn from the implementation and improve those policies over time. So again, you will hear a lot, on the next slide, you'll hear a lot of references to the Equitable Enforcement Advisory Committee. And that's because they were instrumental in shaping this model policy. The advisory committee included 11 participants from local and national groups, and they represented a range of sectors, including affordable housing, legal aid, restorative justice, addiction treatment, and public health, of course. So we are tremendously grateful for their incredible insights and contributions, and in really shaping the equity components of this policy. So I did, in our process with the advisory committee, we did go through a process of just identifying our shared values. And so I wanted to share this visual with you. This is the actual brainstorming that we did for the advisory committee. And, despite the wide range of sectors represented by these different partners that we worked with, we all were really coming together around shared values. And so I think this is an important emphasis to really identify those commonalities and those shared values where that we're going to have some tension in the conversation in the future. And the next slide, ultimately, what ended up happening was the committee really coalesced around a simple but very powerful shared goal, and that is healthy and stable housing for all residents. So really, to boil it down, that was really kind of the central theme and thinking behind the development of this. And so with that sort of glimpse into the process, I'm going to hand it back over to Marisa, and she's going to start walking us through some of the specific elements, provisions in the ordinance.
Great, thank you, Rachel. So this intensive community and stakeholder work was instrumental in shaping the actual model policy. As you can see at the bottom of this slide, there is the link to the National Model Ordinance, which I believe is also provided in the chat for ease of access. A few highlights of the policy itself: it's comprehensive. It covers all products that may be smoked or vaped. It covers all portions of the property grounds, including both indoor and outdoor areas. And the policy also does not provide for any exceptions for existing residents to continue to smoke, since doing so would, of course, undermine the policy itself by allowing parts of the property to not be smoke-free. The big picture is that this is a model policy that reflects best practices from a public health perspective. That said, it's still up to each community to assess what their own approach should be toward adoption and implementation of a smoke-free ordinance, and then decide which components of the model are appropriate for that community. That also includes, importantly, checking with an attorney licensed in your jurisdiction to make sure that there are no issues with respect to preempting a municipality's ability to pass a smoke-free multi-unit housing ordinance. So in that same vein, it's worth noting that every community has different capacity and means with which to pursue local policies, and it is important to plan for and adjust to any given community's resource capacities and assets. And one key component of our ordinance is the importance of early and thorough community engagement before the policy is even proposed, during the policy consideration process, and continued engagement after the ordinance is adopted to ensure smooth implementation. We can't emphasize enough the importance of continued community engagement throughout this process, and it's crucial for the successful implementation of any ordinance that's going to be adopted. Support for the policy development process may come from partner organizations or philanthropic partners, especially in supporting startup costs, and resources for effective implementation of the ordinance may be recouped through things such as rental license fees. Again, this is a model policy, and it's expected that communities will approach this model with creativity and flexibility, and not every component is going to be achievable or workable in every community. So some of the questions communities may ask of themselves are, what is workable in our community given the resources at our disposal? Or how do we stay true to the intent of this model policy and the objectives of ensuring smoke-free housing for multi-unit housing residents without jeopardizing housing stability for any multi-unit housing residents? So as Rachel discussed, the Equitable Enforcement Advisory Committee was formed to help us develop enforcement options that were not criminal or purely punitive in nature. And as the committee convened, it became clear that the whole policy itself should be examined and not just the enforcement options. So turning to the specifics of how the committee shaped the entire policy, on this slide, you'll see the key areas that were influenced by the advisory committee and the stakeholder process. And these include the option to establish a designated smoking area, direct the responsibility to ensure a smoke-free environment to landlords and HOAs, eliminate any additional lease requirement that the grounds be smoke-free, prohibit any misuse of the ordinance as a form of retaliation, allow a tenant who is regularly exposed to secondhand smoke to terminate a lease term early without financial liability, ensure the ordinance is complaint-based so that there's no police involvement, and finally, utilizing a compliance-focused enforcement process to ensure housing stability for all residents. And I'll touch upon each of these. So first, the committee had significant discussion about whether a designated smoking area should be allowed or not on multi-unit housing property grounds. And while for public health reasons, of course, a DSA is not desirable, the committee balanced that against the importance of gaining compliance and also to ease implementation of the smoke-free policy. So resultantly, the committee decided that the model policy should not include a DSA, but an option to include one, as well as suggested language regarding the parameters of a DSA, should be included in a content box. And the group felt a DSA was important to, as I mentioned, to help achieve compliance, particularly in a place like Minnesota, where the extreme cold can create a lack of a place to smoke outdoors and would resultantly encourage residents to smoke inside their units. And so we included this very limited DSA language. It allows for a DSA, but keeps it very structured and as protective as possible. So things like 25-foot buffer, the DSA can't be located near other outdoor common areas such as pools or playgrounds, and there must be a clearly marked perimeter. Another focus of the policy was to spell out landlord and HOA responsibilities. There are, of course, pros and cons to this approach of placing the responsibility of enforcement into the hands of a landlord or an HOA. Some of the pros are that the HOA or landlord are already charged with other enforcement of other policies, so they have the means to do so. And there would be direct accountability to the jurisdiction for the responsibility of HOA or landlord enforcement. Another advantage is enforcement by the HOA or landlord removes any risk of criminal or administrative penalties assessed against residents. And similarly, HOA or landlord responsibility also removes the potential for any involvement by law enforcement. Some of the disadvantages are that HOA or landlord responsibility could always be abused to pursue harsh measures against residents, particularly in the form of steep fines or eviction. Similarly, there's the risk of possible discriminatory or targeted enforcement by HOA or landlords against certain residents. And there's the risk of setting up an inequitable power dynamic between the HOA or landlord and resident. And in the context of being in a jurisdiction where there's no enforcement obligation, this could also translate into lax enforcement. With all that said, continuing the exploration of landlord or HOA responsibility, the committee sought to ensure that the responsibility for the policy was not just focused on residents, but to also emphasize more generally a landlord or HOA's heightened responsibility to promote a healthy environment for everyone. So this would include specific responsibilities for landlords and HOAs, recognizing their unique role, including they must not permit smoking in non-smoking areas, of course. They must remove any and all ashtrays and ash cans. They're responsible for the acts of their agents, employees, or others in their control. They must take reasonable and timely steps to investigate infractions and to enforce the policy, including responding to complaints as they receive them about ordinance infractions and doing so in a timely manner. They must provide a copy of the ordinance and written notice about the ordinance to all residents, and they must post signage throughout the property grounds. So next, the committee explored whether rental properties should require specific lease provisions about the smoke-free ordinance. And many California jurisdictions, for example, have similar ordinances where it's in fact a requirement that the smoke-free provisions be incorporated into the residential lease agreement. The committee recognized the problem that including the no smoking policy as a lease provision may mean a lease violation can quickly escalate into eviction proceedings. So they thought it was important to allow the landlord the flexibility in whether to include this in a lease agreement. And whether it's ultimately part of a lease has no bearing on the policy itself, since the resident is still required to abide by the smoke-free ordinance. But by not requiring a lease provision, we do reduce the risk that people could lose their housing for alleged lease violations. The committee was also concerned about how such a policy could be exploited to harass or retaliate against residents. So we included in our model this provision to make clear that any use of the ordinance as a tool to intimidate, harass, or retaliate would be a violation of the ordinance itself and subject the person responsible to for the misconduct to potential penalties. Another provision considered by the committee is to protect tenants when they are repeatedly subject to secondhand or thirdhand smoke by allowing them to terminate their lease early. So, and this isn't a new concept. It's modeled off provisions in some states that allow for domestic abuse survivors to break their lease to escape the threat of further violence, stalking, or other forms of abuse. So in our model, the tenant may break the lease if their health is jeopardized by ongoing exposure to secondhand smoke, and they can go ahead and terminate the lease without penalty or liability, specifically meaning that they do not forfeit their security deposit, nor would they be responsible for paying rent for the remainder of the lease term. The committee also discussed at length the importance of ensuring that people who live in multi-unit housing are not subjected to over-policing as a result of this policy. And the solutions were to have a complaint-based process, which means there's no proactive investigation conducted by city inspectors or by law enforcement. Rather, enforcement is primarily the responsibility of the public health department, because they have the expertise and ability to carry through on the enforcement process with the support needed for residents, as well as landlords and HOAs, which Rachel will describe in more detail in just a moment. The bottom line is that this approach to compliance and enforcement is specifically intended to reduce the risk of negative interactions with inspections or with law enforcement. So with that, I will turn it back over to Rachel to talk in more detail about the equitable enforcement provisions.
Great, thanks, Marisa. And please, as you all have questions that are coming up, feel free to add those to the Q&A or the chat function, and we will get to those at the end. So I'm going to talk about the specific equitable enforcement components that we included in this model. But again, I want to go back to our advisory committee process because that was really instrumental in helping us shape these provisions. So the committee did carefully consider any unintended consequences of the ordinance, specifically around these enforcement pieces. And so that really helped us to reimagine how we would approach the enforcement of this kind of a policy. And it really, the reimagining rested on a few themes. First, enforcement absolutely must not engage law enforcement. And it must not promote the over-policing of communities. The ultimate goal in the policy was to be compliance. So all steps to promote compliance must be pursued first before penalties. So that's why you'll hear us talk a lot about the education, the planning, notice, graduated enforcement, support for cessation and treatment for nicotine dependence. Those were all really important themes that came through the discussions that we had. So in considering all the unintended consequences, we did need to look at what are the current penalties, and it's mostly primarily California communities have actually enacted some, a large number actually of communities in California have enacted similar smoke-free multi-unit housing ordinances. And some of them do include small criminal penalties. And so one of the things early on we wanted to discuss was, how appropriate, or is it appropriate? What are the pros and cons to having criminal penalties in an ordinance like this? And the group very quickly eliminated the idea of using criminal penalties for resident infractions. We identified virtually no benefits or pros to that approach, and a lot of problems and challenges to that approach. So you will not find any form of criminal penalties for residents in the ordinance. And then moving on to landlord and HOA infractions, the group had some kind of spirited conversation about this. Some felt that there were some benefits to having a criminal penalty for landlords and HOAs for not upholding their part of the ordinance. But really, in the end, the cons won out. People just felt that in this context of housing, the stakes are too high to initiate, interaction with law enforcement and that sort of thing. So ultimately, we decided not to include those criminal infractions for the landlords and HOAs. So moving on to the next slide, what we did decide to do is look at administrative enforcement. But we identified a number of cons to that approach. There are some real benefits of not having criminal fines and criminal consequences, but there are also some cons to administrative enforcement. Fines can be onerous. It's possible that there will be targeted enforcement, and certainly fines sometimes can escalate if they go unpaid. And so the committee really wanted to see this as an opportunity to reimagine, revision what the administrative enforcement process would look like. And this is essentially what we came up with for a reimagined format. So as Marisa mentioned, it is primarily complaint-based. So there's no proactive investigation happening to look for violations. It really is up to, those affiliated with the housing to actually lodge complaints with public health. Again, no criminal penalties. We developed 2 separate sets of penalties for landlords, HOAs, and residents, because they have different responsibilities, different, issues that they can address with separate penalties. So that's how we wanted to approach it. And then, of course, the penalties are graduated, and they're truly structured to support compliance and not just be purely punitive. So in this slide, I know you can't read it, but the slides will be made available to you. So you'll be able to dig in on this a little more in the future. But this is a flow chart we created to just boil down the overall process for resident violations. And so I'm not going to talk through all the details of this, but I'm going to highlight in my next handful of slides some of the key elements of this process that we want to share with you. So first and foremost, the first violation, and this is the actual language from the model policy, for a first violation, and this is for residents, if the local public health department receives a complaint about smoking in violation of the ordinance, then their first step would be to provide a written notice to the resident. And it would have information about that complaint, the enforcement process for possible future violations. It would have information on the harms of secondhand smoke. And very importantly, it would have cessation resources and also the process for refuting the complaint. Again, this first step in the process is to really try to foster compliance by the resident. And so it's not a punitive, it's more of a supportive, sharing information and educating that resident about the ordinance. If there is a second complaint for the resident, then the next step is the public health department would activate this community-led response team. And this was a really exciting development. I think that, not unheard of, but in this context, it was really important to the advisory committee to look at a next step that would really kind of handhold residents into compliance. And so the idea was, let's engage a team of experts, and by team, it might be 1 or 2 people. But the idea is to have experts with cessation expertise, community health worker, social worker. The barriers to compliance may be that the person is unable to comply for, a whole host of reasons. They, have their educational level. They can't read the notices. They don't understand what the limitations are. So the idea of the response team would be to identify if there are barriers and then help remove those barriers so that the resident can comply. So we were very excited about this sort of added step to the process. We know that it sounds like it could be pretty resource intensive, but it really could be 1 or 2 people, ideally that have training and expertise to really help the resident achieve compliance. So moving on to a possible third resident violation. This is where there would be, investigation and possible civil citation. And as the penalty for that citation, the committee really identified 3 different options. One would be the resident could pay a civil fine. And I want to really emphasize on this particular piece that the civil fine would be based on ability to pay. So you'll see the language here under letter A, civil fine pursuant to the fine schedule established under section 7. Under Section 7 of this model ordinance, there is direction for the Public Health Department and the city and county attorney to actually identify what we call a day fine system, which really takes into account the ability to pay by looking at sources of income, assets, but also what expenditures they have. So, an individual tenant may be able to pay a higher fine versus a tenant that has 4 children, for example, and has greater economic responsibilities. So that is a really key component, that if a fine is going to be used, it must be based on ability to pay. And that was really a key line in the sand that the group drew. A second option is for that resident to participate in a community service program. Ideally, a community service program would be relevant to the issue at hand. So, for example, participating in education training about the harms of secondhand smoke, cessation resources. We did decide to add an extra layer and also include the option of actually the resident participating voluntarily, participating in evidence-based tobacco cessation program to help them with their nicotine addiction. And, again, with that eye towards compliance, really supporting that compliance. And then a third option that we included in the model is a restorative justice process. And that process would require that all the interested parties would have to be willing to participate in good faith. So all of the sort of bedrock principles about restorative justice would need to be followed, with the goal, of course, of being to build the community to not be, blaming or finger pointing, but really to come to a place of agreement and, again, supporting residents in compliance. So, and then finally, if there are any subsequent violations within, that period of time, it would go back to, really looking at initiating the ability to pay civil fine, community service, or restorative justice. But so as you'll see, this is the graduated enforcement process that the group decided to move forward with. And then finally, for residents, if there is no violation within 1 year of that first violation, then the whole process is reset. The group felt very strongly that it was so important to have the opportunity for residents to redeem themselves and to remedy the situation and give them that chance to start from square one instead of just continuing to escalate, even though they were, trying their best to comply with the ordinance. So, and then the next slide, I wanted to highlight that, throughout this process, it was also very important that we have due process protections for residents and the landlords and HOAs. And so you'll see here the language that we included in the model ordinance that does require notice, hearing process, and the opportunity for appeals. So that is also very important to make sure that there is not, an abuse of this ordinance or retaliation or targeting. So next, I'm going to talk about, again, another impossible to read flowchart for you that you will be able to check out once we share the slides with you. But this is the process for the HOA landlord violations. And I'm going to just highlight a few of the steps here, but this is a good diagram that shows this is how the process would flow. So you can check that out when we share slides. But again, for HOAs and landlords, the goal is, again, compliance. So we, are focusing on trying to give them a chance to remedy, but also throughout the entire process, the public health department, before implementation of the law and after, they would be providing ongoing training and assistance, template letters of notice, possibly even free signage, or at least design for signage, and really trying to make it as easy as possible for the homeowners associations and landlords to comply with the law and do that in a productive way, not just a punitive way. So moving on to the next slide, this is the actual set of penalties in the model ordinance. And what you will see is that landlords and HOAs are fined. And it's a civil fine, but the group really did feel that some of the other steps that we allow for residents were not necessarily appropriate to pull over into addressing HOA and landlord infractions, in part because they do have that heightened responsibility to manage the property, to enforce laws, enforce policies. And so the idea was moving directly to a fine was appropriate in this circumstance. However, there was some discussion that certainly it could be allowed that after a first violation, the public health department would just do outreach to that landlord or HOA and really give them resources and background information about the ordinance so that they are well aware and maybe could remedy any problems. But you'll see those fines escalate. And there also is a restorative justice alternative. If all parties agree, and the, that is appropriate in the circumstance. So, and then I also wanted to just note that, and back to the slide, one of the important things is that if there's a resident complaint, the idea is to really have two-way communication. And so the idea is that public health would provide information on any steps that they took back to that resident so that they were, the feedback loop is there. So, and then again, we have a reset provision for the landlords and HOAs. Again, it was important for the group to, really want to have that opportunity for them to remedy. So with that, we can take any questions that we had in the Q&A. Yeah, so one question here, does the model policy outline options or suggestions for tenants who are being exposed to secondhand smoke, but have a landlord manager who is not enforcing the policy? And I think, one answer to that is that was one of the reasons that in this model ordinance, we really built in those key features to ensure that landlords and HOAs are held accountable for their responsibilities. So what the person could do is, if that resident was aware that, let's say, the landlord or HOA was allowing certain residents to smoke, they could lodge a complaint with the Department of Public Health, and an investigation would be done, and the process followed for potential landlord HOA violations. Yeah, so I'm seeing another question here. Would ability to pay, in the example, single person or family of 4 children, to pay be fair housing violation of family status? And I think for that question, I think the idea is that all of the expenses and income streams would be taken into account. So the determination is not necessarily based solely on family status. It is based on what is the overall economic picture for the individual. So I believe that would be permissible. So, and I know we had another question about nuisance. Some California jurisdictions have nuisance as a possible violation. Does this model include a nuisance provision? Marisa, do you want to take a shot?
Yeah, so the that is correct that California jurisdictions do include nuisance, and that was something that the committee deliberated on and decided against for our model ordinance. Again, nuisance can be used to target people, and in the context of dealing with addiction to nicotine products, the committee didn't view that as as an approach that would be helpful for any of the stakeholders involved. So it was definitely a deliberate decision to keep nuisance out of our model ordinance.
Great. And I see another really great question here. Is there a model that doesn't depend on the Department of Public Health for enforcement? Many public health departments don't have staffing or funding for enforcement. And we know that is absolutely true. In fact, many jurisdictions don't even have a public health department. So, we chose to include public health department as the enforcement arm of this because of their experience typically with clean indoor air issues. I think, it could be your Department of Inspections. It could be, another arm of your city, county staff. But the overall goal, again, is to really ensure that it is not law enforcement. We don't want police coming in and knocking on doors. We want to, ensure that it's a process that is focused on compliance and not exacerbating over policing of communities. So do you have thoughts about that too, Marisa?
No, I was just going to try to squeeze in another question before we finish up. But someone asked for us to explain a little bit more on the ability to break the lease and if that's included in the California model ordinance, and is there a possibility for that to be abused. And I think, in our model ordinance, the ability to break the lease, there has to be, I believe, 3 substantiated violations of, continued exposure to secondhand smoke or thirdhand smoke before you can go ahead and invoke that right under the ordinance. And so that I think really limits the or diminishes the ability for someone to abuse or exploit that provision. Again, because it's modeled off of a situation relating to domestic abuse survivors, there really is not there's no appetite for abuse to terminate the lease. I mean, that's a severe disruption for someone who's going to be exposed to secondhand smoke and they have a respiratory illness and it's just the landlord's not doing anything about it. It's pretty disruptive for them to get out of that lease. So I would imagine it would be a last resort and something that I would be surprised to see it subject to abuse. But yeah, we did incorporate that it would be upon the 3rd substantiated violation.
And we are at time. So we are so grateful that you joined us today. And for the questions that we didn't get to in the live presentation, we will try to follow up with you in the near future to get you your answers. But also, please feel free to reach out to Public Health Law Center for any questions regarding this model policy or smoke-free housing in general. We are funded to provide technical assistance specifically in this area. So we are happy to help you and we look forward to talking with you soon.
Bye. Thank you.